Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. We are dealing with a case relating to professional ethics. So, final year students, be alert. 2 days back, while the virtual court is going on in Karnataka, the Chief Justice of Karnataka High Court, Mr. Rituraj Avasthi, along with a bench consisting of Justice Krishna S. Dikshit and Justice J.M. Khazi, orally stated that the act of the advocate Mr. Tahir Ahmad in filing the affidavit signed by him, it amounts to misconduct. You all know misconduct is not defined, but still Section 35 of the Advocates Act 1961 empowers the Bar Council of a state or the Bar Council of India to take disciplinary action on an erring advocate who exhibits either professional misconduct or other misconduct. Simply to say, misconduct is the act which an advocate is not supposed to do professionally. If you deviate from the conduct, then you are liable for the so-called misconduct. The punishments all of you know. Now, why filing of affidavit by the advocate is taken as misconduct? For that also you have to think of Section 139 of the Civil Procedure Code deals with the affidavit. The affidavit is nothing but a sworn statement given by a person regarding the facts which are known to him and which are within his or which are exclusively within his personal knowledge, and he has to verify and sign the same. But the Karnataka Civil Rules of Practice 2017, they say that an advocate also can file an affidavit. On what? On the matters in relation to the subject or already on the matters which are in the court. That's all. Simply to say, an advocate is supposed to attest the affidavit, but he is not supposed to file the affidavit. He can file it only when the original case is filed and when any matter in dispute has to be settled. That's all. తెలుగులో చెప్పాలి అంటే ఎఫిడవిట్ అనేది 139 సిపిసి కింద కేవలం పార్టీ మాత్రమే వేయాలి, లాయర్ వేయకూడదు. కానీ సివిల్ రూల్స్ ఆఫ్ ప్రాక్టీస్లో లాయర్ వేయొచ్చును. ఎప్పుడు ఆల్రెడీ కేసు వేసిన తర్వాత ఆ మ్యాటర్లో ఏదైనా కొంచెం అనుమానం ఉంటే ఇఫ్ ద కోర్ట్ ఆస్క్స్, జడ్జి గారు ఏదైనా అఫిడవిట్ వేయమంటే వేయచ్చు, లేకపోతే మనం కూడా వేయచ్చు ఆ మ్యాటర్ మీద. అంతేగాని మన యొక్క పర్సనల్ నాలెడ్జ్ ఉండే వేయకూడదు, అంటే మనం పార్టీ కాకూడదు. దిస్ ఈజ్ వాట్ ఈస్ స్టేటెడ్ బై Honorable High Court Chief Justice. So this happened on day before yesterday. So this is all regarding when the very famous hijab case arguments are being heard. You may be knowing, full court, Karnataka High full court is hearing only on this hijab issue. It all started from Udupi. You all know, previously I have made a video in this aspect also. On February 10th, the High Court of Karnataka, they have given interim orders stating that where the uniform is prescribed, then till the decision of the court comes, so people cannot wear the so-called religious dress like hijab or turban, whatever it is. But when the court has come up, when the matter has come up for hearing the court, the advocate started saying that, Your Honor, Milord, I have seen it personally. Milord, there are so many institutions which are misusing the interim orders given by the court. So where there is no uniform prescribed, people come with any dress they like. So they can come with the so-called hijab, but still people are not, the management is not allowing. So in Udupi, the management has got to such an extent that they have prepared a room for checking these people, remove the hijab and then only allow them into the college. This is the thing happened. Then the judge stated, how can you say that? Say, Your Honor, already I have filed an affidavit. In the affidavit, I have enclosed the so-called media reports also. Right? But the bench said immediately, particularly Avasti sir, Justice Avasti, he stated that we are rejecting the affidavit. How can you file the affidavit? Who is that Fatima and two others, though they have Udupi, they have filed the case. So they have to file the affidavit, not you. It amounts to misconduct. But Advocate Tahir says that a counsel can file affidavit on the same as it is a material fact. So right, but the bench said this is not the correct practice, Mr. Lawyer. A lawyer cannot swear an affidavit. You cannot swear and file an affidavit. We can't allow this small practice. So, even though the Advocate Tahir stated that he attached so many media reports, no, it's not agreed. And other side, that is Advocate General. So he is Prabhuling K. Navadgi. So Marathi name, Karnataka name. Prabhuling K. Navadgi. He has very clearly stated that other side bench, he has clearly stated that it is highly objective and the petition itself, affidavit itself defective because the affidavit is not verified. No verification statement by the person has come. So therefore, it is defective. In this connection, Advocate Tahir clearly stated that, Your Honor, the parties are in Udupi. It is very difficult for them to come to Bangalore and sign the affidavit within such a short time, within one day. So, therefore, I am constrained to file the affidavit. But court said no, we can't do it. So here, even though Tahir Ahmed cited the Karnataka Civil Rules of Practice 1967, I'm sorry, I told in the beginning, I told 2017. 1967, the advocate can file memo, but as to the facts or extension of facts, that's all. So anyway, so in this connection, to conclude, I want to tell you, please learn that or observe that there is no clear-cut definition for a professional misconduct. The court can take anything as misconduct here. They can take it as a professional misconduct, they can take it as a contempt, so please be careful. So in this video, we have learned two aspects. One, section 139 of the CPC regarding filing of the affidavit, and second point, the advocate should not file the affidavit as a party in person because the party has to give the certificate stating that they have verified the fact, they know the facts to their nature, all these things. So with these two, if you know these 2 points, I'll be happy that you have learned something legally. Okay, thank you very much.